Good evening, everyone. My name is Jeanne Mirer, and I did somewhat of a PowerPoint for you because I'm a labor lawyer, just so that you know that. And my whole life I was doing employment and labor law, and one day somebody said, "Oh, do you want to go to South Africa on a trip?" Because they're doing a conference on the new Constitution. This was back in 1991, and they'd like to talk to this is the ANC Constitutional Committee. They want to talk to some U.S. progressive lawyers about what they should be doing for their own Constitution. And so I said, okay, I'll go, and I wrote a paper on an issue relating to employment law and racism and affirmative action, and I wound up going to South Africa, and then I wound up getting involved in more international solidarity things, and suddenly I was made president of the International Association of Democratic Lawyers, which is the association, the international association to which the Lawyers Guild belongs. In the meantime, that was like a 16-year journey, but in the meantime, I realized that I had to learn something that had been largely invisible in law school and continues to be invisible in daily discourse, and that is, what the hell are we, what is the laws that relate to international relations? But let's go to the UN Charter. It was signed in June of 1945 before the use of the first nuclear weapon, but it came into effect in October. It was ratified by the United States, and one of the things about a treaty that's ratified by the United States is that under our Constitution, under Article 6, Section 2 of the Constitution, any ratified treaty becomes domestic law. So at a certain point, even though we're talking about international law, the duties, once we've ratified this treaty, are domestic law. Well, what does the UN Charter say about the use of force? It says, all members shall settle their disputes by peaceful means in such a manner that international peace and security and justice are not endangered. It also says that all members shall refrain in their international relations from the threat or use of force against the territorial integrity of another state. That's pretty clear. Not supposed to threaten war, you're not supposed to settle your disputes in any other way that's not a peaceful means. Now, under the Charter also, they all agreed, therefore, to outlaw recourse to war as a means of resolving international disputes. And actually, Articles 33 to 38 set forth mechanisms for settlements of disputes. These include such things as negotiation, inquiries, mediation, conciliation, arbitration, judicial settlement, resort to regional agencies, or other peaceful means. The only exception in the UN Charter to the non-use of force is in the area of self-defense. In Article 51, there's the recognition of what's called the inherent right to self-defense, but it is a very narrow exception. It is limited to the use of force only to repel an attack, an ongoing armed attack on the territorial integrity of the state, and it's only until the Security Council of the UN can act to preserve international peace and security. The attack also, the response must also be proportionate to the attack. Furthermore, self-defense justifies an attack only when the necessity of that self-defense is instant, overwhelming, and leaving no choice of means or moment for deliberation. So now I want to turn to the other source of law that makes wars of aggression illegal, and that's the Nuremberg Principles. How many people have read the Nuremberg Principles? Okay. All right. Probably what most people know about the Nuremberg Principles is people say, oh, you can't just be following orders and things like that. Well, actually, there's many things that the Nuremberg Principles have, and one of them is, and let me just basically for the history, the background, after the war crimes trials of Nazi leaders and their abettors after World War II, there was this, because the trials took place in Nuremberg, there was the Nuremberg Charter, which then later was transferred by the UN Law Commission into these principles. They apply to persons, not just states, persons. And they define war crimes and crimes against humanity. And by defining those actions, and they also define actions that are prohibited in war, so they're in that way part of international humanitarian law. But they also prescribe wars of aggression. Now let's look at the principles. Principle 1, any person who commits an act which constitutes a crime under international law is responsible, liable for punishment. Can't be any clearer than that. Number 2, the fact that internal law doesn't impose a penalty for an act which constitutes a crime under international law does not relieve the person who committed the act from responsibility under international law. Number 3, the fact that a person who committed an act which constitutes a crime under international law acted as a head of state or responsible government official does not relieve him from responsibility under international law. President Bush, Pinochet. The fact that a person acted pursuant to an order of his government or a superior does not relieve him from responsibility under international law, provided a moral choice was in fact possible to him. Number 5, any person charged with a crime under international law has a right to a fair trial on the facts of the law. Number 6, the crimes hereinafter set out are punishable as crimes under international law. The first is the crime against peace, which is the planning, preparation, initiating, or waging of a war of aggression or a war in violation of international treaties, agreements, or assurances. Another, participation in a common plan or conspiracy for accomplishment of any of the acts mentioned under Section 1. Coalition of the willing. B, war crimes. Violations of the laws or customs of war, which include but are not limited to murder, ill treatment, or deportation to slave labor, or for any other purpose of civilian population, or in occupied territory, murder, ill treatment of prisoners of war. You can read the rest. But there's a reference here, not justified by military necessity. I'll get to that in a minute. Crimes against humanity. These include murder, extermination, enslavement, deportation, any other inhuman acts done against the civilian population, or persecution on political, racial, or religious grounds when such acts are done or such persecutions are carried on in the execution of or in connection with any crime against peace or any war crime. So if you're in an illegal war and you do any of these things, it's a crime against humanity. Now the 8th is, the bottom line here is complicity in a war crime against peace, complicity in the commission of a crime against peace, a war crime, or a crime against humanity is a crime under international law. These are pretty strong principles. And when you read them together with the UN Charter, which the UN Charter applies to states, Nuremberg applies to persons. All right, now let's turn for a minute to international human rights law. In 1948, the UN adopted the Universal Declaration of Human Rights. The rights include all basic civil liberties, but also the right to an adequate standard of living, including such things as food, shelter, medical care, social security, living wage, jobs, actually the right to organize unions, and so forth. Now, let's talk about international humanitarian law. Whether a war is legal or illegal, all parties are bound by international humanitarian law. And the purpose of international humanitarian law is to lessen the impact of the war on both combatants and non-combatants, but especially on non-combatants or civilians. There are treaties which outlaw specific weapons, such as poison gases, and are designed to protect both combatants and non-combatants. But the law specifically prohibits attacks on civilian and civilian objects. You've heard people when they were talking about, I think, the Gaza war, there was a reference to proportionality. Remember people talking about proportionality? Well, proportionality really doesn't relate to, body count. It relates to whether civilian deaths or injuries are excessive in relation to the military advantage of the attack. So really, international humanitarian law is what we call rules of distinction, civilian versus combatant, and proportionality, distinction and proportionality. In other words, you don't attack civilians, and to the extent that your military advantage doesn't need it, you should not be attacking civilians at all. It's a principle of distinction between civilian and military target and the amount of value or power used in the attack. With respect to human rights law, although it is independent from international humanitarian law, countries at war are not exempt from their duties under human rights instruments. Now, I mentioned the Universal Declaration of Human Rights, and that there were these two treaties or two covenants that were issued in 1966. The International Covenant on Civil and Political Rights, which is the ICCPR, and the International Covenant on Economic, Social, and Cultural Rights, which was, just so it's clear, the U.S. refused to have both covenants in one document because they didn't believe that economic rights belonged anywhere in any document, and as you can see, the U.S. has not ratified this document. So many countries of the world have ratified it, however, that I think there's a good argument that it already is customary international law. That's one of the things when you look back as to how does customary international law get created. It's because so many countries adopt it that it develops that higher level of status of being legally binding rather than morally binding. There's also the Convention Against Torture, and this is an important convention. It was issued in 1984. Torture is defined as any act which causes severe pain. You can actually see it, but we in this country have a really big problem with the fact that there are torturers, people who engaged in torture, wrote memos to justify torture, who are on the Ninth Circuit bench and teaching in law schools. And this is not a good situation. And I've been, the next page is also the continuation of the definition of torture. It also is enforced through the Committee Against Torture, and there's actually a law in this country that says torture is a criminal offense. It's in the War Crimes Act, and there's also the act for war crimes committed by persons in this country, and the statute against torture addresses torture that we engage in overseas. There are all these potential violations, and let me just say this. The ones that I am most concerned about is the fact that we're engaging in illegal wars. There's no question in my mind that the war in Afghanistan, the war in Iraq were illegal. And the question is, what can you do about it? Well, in the law, I mean, law students here are probably taught that there's a right to a remedy. And in fact, that right is pretty much enshrined in most of the international instruments. They talk about the right to a remedy. They talk about the need for parties to affirmatively engage in actions to suppress violations of international law or crimes of the like. But one area, unfortunately, that is, I mentioned first the Court of Justice, and the International Court of Justice in The Hague has two aspects. One is it decides cases between countries. The other is it takes questions from the UN and issues advisory opinions. So the opinion on the legality of nuclear wars was an advisory opinion that had come to them from the General Assembly. The problem is that the U.S. has interpreted the language of Article 94, which says that each member country shall undertake to comply with the decision of the Court of Justice as meaning that it isn't really bound. And there was a really bad case last year called Medellin versus Texas, where a decision by the International Court of Justice about whether certain people here Mexican nationals who were on death row and who didn't get their rights to talk to their consulates after they had been arrested and before they were interrogated and so forth. Those people had asked for their consular rights after the fact, after they were convicted. And there was a case brought in by Mexico against the U.S. That said these people have to get their rights. And they won in the court, in the International Court of Justice, but then the Supreme Court took the position it was not self-executing. They had to have a separate statute enforcing it, and Medellin was killed. They went through with a sentence, a death sentence. But anyway, so this is not a very good. This is a problem for us, and also the U.S. basically pulled out of the court after in the 80s, before the Contras took over in Nicaragua. We had mined the harbors there and had claimed it was self-defense, and the Court of Justice said, not self-defense, and so we got. There was a ruling against us, and we basically pulled out of the court. There is recourse, though, to the Security Council if a party to a World Court decision doesn't agree. But the problem is that against the U.S., which has a veto on the Security Council, it might not be a very helpful remedy. Now let's talk about some of the other areas in the UN where there is potential remedy. The UN Human Rights Council, which is probably about 4 years old, replaced the old Human Rights Commission, has decided that every few years it's going to do what's called the Universal Periodic Review of the human rights records of each country. And on November 5th this year, the U.S. is coming up for its review, and I have here in my hand a 91-page book done by the U.S. Human Rights Network, which has all of the reports that were done by civil society. I did the one on labor, saying these are the problems and so that the U.S. can be questioned by the members of the Human Rights Council in November when they come up for their periodic review. Also, one of the problems, though, is that all the treaty bodies, the ones that enforce the convention, the various covenants and the conventions, most of their abilities after even investigating complaints, their power is limited to what we might call shaming. I'm going to skip over the high contracting parties, but to the conventions, although this is one remedy, they haven't really, it hasn't much been used. Universal jurisdiction. Peter mentioned this is something, there is a working group, an international working group of lawyers that are looking at this around the world. CCR has done most of the cutting edge work in the United States, trying to get people like Rumsfeld and others held accountable in other countries. But the bottom line is there are some crimes which are so heinous, such as torture, promoting wars of aggression, that theoretically all jurisdictions should have an interest in suppressing them. And that's really the ideological underpinning of what universal jurisdiction is about. And there are several states, such as Spain, Belgium used to have a good one, the UK I think is experimenting, I don't know about France, I think France may have one now, which sets out the procedures for cases of this type. The U.S. also has a war crime statute which outlaws torture, but these have not been used to prosecute anyone who's responsible for implementing the policies of torture. There are several persons who are being investigated for actions going beyond what the torture memos that were written by John Yoo and all have said, but not for the torture that he and the others allowed for. And the last remedy is the International Criminal Court. The International Criminal Court was set up in 1998 by the Rome Statute. It had gone through a long process of negotiation. A lot of civil society groups were part of it. IADL participated in the development of it. It basically outlaws many of the actions which would also violate provisions of the Geneva Conventions, torture, genocide, and so forth. Bill Clinton signed it, Bush unsigned it. So we are not part of it at this point. And in fact, we've pressured a lot of countries to say that are members of it, that they would never seek to prosecute U.S. soldiers who might do something wrong on their soil, because even though they're in the U.S., if you commit a crime in the state where they are a part of the International Criminal Court, you could possibly be brought to the court. And so there are the so-called bilateral agreements. There hasn't been enough pressure placed on Obama or any subsequent person to accede to the International Criminal Court. As far as I'm concerned, it's one of the better remedies we have, and it's exactly set up to do what's happening now, which is if a country is not willing to prosecute itself for its own war crimes, then you need some other international body that doesn't have the internal political pressure to do it. And that's one of the things that, to me, is very important for movement. The bottom line is that these remedies, many of which are not all that effective, are at least things that we should know about as possible remedies. Right now, the thing that I am most afraid of is the ongoing impunity. Do people know what impunity means? Impunity really means that if you violate a law long enough and consistently enough, people start thinking it's okay to violate the law, and that's what is impunity. And that's the thing that's the scariest part about not having the kinds of remedies for the illegal wars that we're now engaged in. Thank you very much.
We need to educate
educate ourselves, because until we have a critical mass of people being able to say, not just the war is immoral, but it's illegal, or this is why it is, and so on and so forth, you know, you're not going to be able to start educating the judges, and you're not going to be able to start educating the rest of the public. And that's one of the issues. That's, I mean, not that that's the only argument. I mean, they are illegal, they are immoral, they've been sapping our treasury. I mean, one of the concerns, you know, there's a book by this guy, Philippe Sands, called Lawless World. I don't know if people have seen it, but Philippe Sands is a British author who, part of his analysis is to compare and contrast the rules-based approach to foreign policy which was what the Americans tried to develop through the UN Charter, and how they've ignored that and compared that to the whole trade regimes and the WTO, and how they set up enforcement mechanisms and their sanctions if you don't follow it, and you could be, you know, all of those other things, and he compared and contrasted those. But he also made the point that large countries, powerful countries, really believe that international law is not for them. It really is for smaller, weaker countries, and if you have to seek the refuge of international law, it only means you're weak. And so the reality is that we are, as we have seen, in using only military power in countries such as Afghanistan, where, you know, there's no way to win a war in Afghanistan. You know, I mean, really, there isn't. I mean, think about what the world would have been like if, after 9/11, George Bush said, we need to, I think that if we have good evidence that Osama bin Laden and the Al-Qaeda is behind this, then we should arrest them and try them in The Hague. No war. I mean, not that I love the Taliban, but they could have been dealt with in the Human Rights Council, you know, or if people had the political will to do it. But we wouldn't have had a war. And of course, you know, he would have talked about all the ways in which he had been developed by the CIA and given money to fight the Soviets and so on, and how can we be mad at him? But just, I mean, just think about what the world would have been like without 10 years of killing civilians and making the world much more unsafe, and developing the so-called war on terror. I mean, these are all connected.